a WikiVidi documentaries production. Don't forget to like and subscribe. Enjoy. President of the United States. The President of the United States is the head of state and head of government of the United States of America. The President directs the executive branch of the federal government and is the Commander-in-Chief of the United States Armed Forces. In contemporary times, the President is looked upon as one of the world's most powerful political figures and as the leader of the only remaining global superpower. The role includes responsibility for the world's most expensive military that has the second largest nuclear arsenal. The President also leads the nation with the largest economy by nominal GDP. The President possesses significant domestic and international hard and soft power. Article 2 of the Constitution establishes the executive branch of the federal government. It vests the executive power of the United States in the President. The power includes the execution and enforcement of federal law, alongside the responsibility of appointing federal executive, diplomatic, regulatory and judicial officers, and concluding treaties with foreign powers with the advice and consent of the Senate. The President is further empowered to grant federal pardons and reprieves, and to convene and adjourn either or both houses of Congress under extraordinary circumstances. The President directs the foreign and domestic policies of the United States, and takes an active role in promoting his policy priorities to members of Congress. In addition, as part of the system of checks and balances, Article I, Section 7 of the Constitution gives the President the power to sign or veto federal legislation. The power of the presidency has grown substantially since its formation, as has the power of the federal government as a whole. Through the Electoral College, registered voters indirectly elect the President and Vice President to a 4-year term. This is the only federal election in the United States which is not decided by popular vote. 9 vice presidents became president by virtue of a president's intra-term death or resignation. Article 2, Section 1, Clause 5 sets 3 qualifications for holding the presidency: natural-born U.S. citizenship, at least 35 years of age, and residency in the United States for at least 14 years. The 22nd Amendment precludes any person from being elected president to a third term. In all, 44 individuals have served 45 presidencies spanning 57 full 4-year terms. Grover Cleveland served 2 non-consecutive terms, so he is counted twice as both the 22nd and 24th president. Donald Trump of New York is the 45th and current president. He assumed office on January 20, 2017. Origin. During the American Revolution in 1776, the 13 colonies, acting through the Second Continental Congress, declared political independence from Great Britain. The new states were independent of each other as nation-states and recognized the necessity of closely coordinating their efforts against the British. Congress desired to avoid anything that remotely resembled a monarchy, and negotiated the Articles of Confederation to establish an alliance between the states. Under the Articles, Congress was a central authority without any legislative power. It could make its own resolutions, determinations, and regulations, but not any laws, and could not impose any taxes or enforce local commercial regulations upon its citizens. This institutional design reflected how Americans believed the deposed British system of Crown and Parliament ought to have functioned with respect to the royal dominion, a superintending body for matters that concerned the entire empire. The states were out from under any monarchy and assigned some formerly royal prerogatives to Congress. The remaining prerogatives were lodged within their own respective state governments. The states agreed to a resolution that settled competing Western land claims. The Articles took effect on March 1, 1781, when Maryland became the final state to ratify them. In 1783, the Treaty of Paris secured independence for each of the former colonies. With peace at hand, the states each turned toward their own internal affairs. By 1786, Americans found their continental borders besieged and weak, and their respective economies in crises as neighboring states agitated trade rivalries with one another. They witnessed their hard currency pouring into foreign markets to pay for imports, their Mediterranean commerce preyed upon by North African pirates, and their foreign-financed Revolutionary War debts unpaid and accruing interest. Civil and political unrest loomed. Following the successful resolution of commercial and fishing disputes between Virginia and Maryland at the Mount Vernon Conference in 1785, Virginia called for a trade conference between all the states, set for September 1786 in Annapolis, Maryland, with an aim toward resolving further-reaching interstate commercial antagonisms. When the convention failed for lack of attendance due to suspicions among most of the other states, Alexander Hamilton led the Annapolis delegates in a call for a convention to offer revisions to the Articles, to be held the next spring in Philadelphia. Prospects for the next convention appeared bleak until James Madison and Edmund Randolph succeeded in securing George Washington's attendance to Philadelphia as a delegate for Virginia. When the Constitutional Convention convened in May 1787, the 12 state delegations in attendance brought with them an accumulated experience over a diverse set of institutional arrangements between legislative and executive branches from within their respective state governments. Most states maintained a weak executive without veto or appointment powers, elected annually by the legislature to a single term only, sharing power with an executive council, and countered by a strong legislature. New York offered the greatest exception, having a strong, unitary governor with veto and appointment power elected to a 3-year term, and eligible for re-election to an indefinite number of terms thereafter. It was through the closed-door negotiations at Philadelphia that the presidency framed in the U.S. Constitution emerged. Article I. Legislative role. The presentment clause requires that any bill passed by Congress must be presented to the President before it can become law. Once the legislation has been presented, the President has 3 options. In 1996, Congress attempted to enhance the President's veto power with the Line Item Veto Act. The legislation empowered the President to sign any spending bill into law while simultaneously striking certain spending items within the bill, particularly any new spending, any amount of discretionary spending, or any new limited tax benefit. Congress could then repass that particular item. If the President then vetoed the new legislation, Congress could override the veto by its ordinary means, a 2/3 vote in both houses. In Clinton v. City of New York, the U.S. Supreme Court ruled such a legislative alteration of the veto power to be unconstitutional. War and foreign affairs powers. One of the most important of all executive powers is the President's role as Commander-in-Chief of the United States Armed Forces. The power to declare war is constitutionally vested in Congress, but the President has ultimate responsibility for the direction and disposition of the military. The exact degree of authority that the Constitution grants to the President as Commander-in-Chief has been the subject of much debate throughout history, with Congress at various times granting the President wide authority, and at others attempting to restrict that authority. The amount of military detail handled personally by the President in wartime has varied dramatically. George Washington, the first U.S. President, firmly established military subordination under civilian authority. In 1794, Washington used his constitutional powers to assemble 12,000 militia to quell the Whiskey Rebellion, a conflict in western Pennsylvania involving armed farmers and distillers who refused to pay excise tax on spirits. According to historian Joseph Ellis, this was the first and only time a sitting American president led troops in the field, though James Madison briefly took control of artillery units in defense of Washington, D.C. during the War of 1812. Abraham Lincoln was deeply involved in overall strategy and in day-to-day operations during the American Civil War, 1861-1865. Historians have given Lincoln high praise for his strategic sense and his ability to select and encourage commanders such as Ulysses S. Grant. The present-day operational command of the armed forces is delegated to the Department of Defense and is normally exercised through the Secretary of Defense, the Chairman of the Joint Chiefs of Staff, and the combatant commands assist with the operation as outlined in the presidentially approved Unified Command Plan. The framers of the Constitution took care to limit the President's powers regarding the military. Alexander Hamilton explained this in Federalist No. 69. Pursuant to the War Powers Resolution, Congress must authorize any troop deployments longer than 60 days, although that process relies on triggering mechanisms that have never been employed, rendering it ineffectual. Additionally, Congress provides a check to presidential military power through its control over military spending and regulation. Presidents have historically initiated the process for going to war, but critics have charged that there have been several conflicts in which presidents did not get official declarations, including Theodore Roosevelt's military move into Panama in 1903, the Korean War, the Vietnam War, and the invasions of Grenada in 1983 and Panama in 1989. The Constitution also empowers the President to propose and chiefly negotiate agreements between the United States and other countries. Such agreements become, upon receiving the advice and consent of the U.S. Senate, become binding with the force of federal law. Administrative powers. The President is the head of the executive branch of the federal government and is constitutionally obligated to take care that the laws be faithfully executed. The executive branch has over 4 million employees, including members of the military. Presidents make numerous executive branch appointments. An incoming president may make up to 6,000 before taking office and 8,000 more while serving. Ambassadors, members of the cabinet, and other federal officers are all appointed by a president with the advice and consent of a majority of the Senate. When the Senate is in recess for at least 10 days, the President may make recess appointments. Recess appointments are temporary and expire at the end of the next session of the Senate. The power of a president to fire executive officials has long been a contentious political issue. Generally, a president may remove executive officials purely at will. However, Congress can curtail and constrain a president's authority to fire commissioners of independent regulatory agencies and certain inferior executive officers by statute. To manage the growing federal bureaucracy, presidents have gradually surrounded themselves with many layers of staff, who were eventually organized into the Executive Office of the President of the United States. Within the Executive Office, the President's innermost layer of aides are located in the White House office. Additionally, the President possesses the power to manage operations of the federal government through issuing various types of directives, such as presidential proclamation and executive orders. When the President is lawfully exercising one of his constitutionally conferred responsibilities, the scope of this power is broad. Even so, these directives are subject to judicial review by U.S. federal courts, which can find them to be unconstitutional. Moreover, Congress can overturn an executive order though legislation. Juridical powers. The President also has the power to nominate federal judges, including members of the United States Courts of Appeals and the Supreme Court of the United States. However, these nominations require Senate confirmation. Securing Senate approval can provide a major obstacle for presidents who wish to orient the federal judiciary toward a particular ideological stance. When nominating judges to U.S. district courts, presidents often respect the long-standing tradition of senatorial courtesy. Presidents may also grant pardons and reprieves. Gerald Ford pardoned Richard Nixon a month after taking office. Bill Clinton pardoned Patty Hearst on his last day in office, as is often done just before the end of a second presidential term, but not without controversy. Historically, two doctrines concerning executive power have developed that enable the president to exercise executive power with a degree of autonomy. The first is executive privilege, which allows the president to withhold from disclosure any communications made directly to the president in the performance of executive duties. George Washington first claimed the privilege when Congress requested to see Chief Justice John Jay's notes from an unpopular treaty negotiation with Great Britain. While not enshrined in the Constitution, or any other law, Washington's action created the precedent for the privilege. When Nixon tried to use executive privilege as a reason for not turning over subpoenaed evidence to Congress during the Watergate scandal, the Supreme Court ruled in United States v. Nixon that executive privilege did not apply in cases where a president was attempting to avoid criminal prosecution. When President Clinton attempted to use executive privilege regarding the Lewinsky scandal, the Supreme Court ruled in Clinton v. Jones that the privilege also could not be used in civil suits. These cases established the legal precedent that executive privilege is valid, although the exact extent of the privilege has yet to be clearly defined. Additionally, federal courts have allowed this privilege to radiate outward and protect other executive branch employees, but have weakened that protection for those executive branch communications that do not involve the president. The state secrets privilege allows the president and the executive branch to withhold information or documents from discovery in legal proceedings if such release would harm national security. Precedent for the privilege arose early in the 19th century when Thomas Jefferson refused to release military documents in the treason trial of Aaron Burr, and again in Totten v. United States, when the Supreme Court dismissed a case brought by a former Union spy. However, the privilege was not formally recognized by the U.S. Supreme Court until United States v. Reynolds, where it was held to be a common law evidentiary privilege. Before the September 11 attacks, use of the privilege had been rare, but increasing in frequency. Since 2001, the government has asserted the privilege in more cases and at earlier stages of the litigation, thus in some instances causing dismissal of the suits before reaching the merits of the claims, as in the Ninth Circuit's ruling in Muhammad v. Jefferson. Data Plan Incorporated. Critics of the privilege claim its use has become a tool for the government to cover up illegal or embarrassing government actions. Legislative facilitator. The Constitution's ineligibility clause prevents the president from simultaneously being a member of Congress. Therefore, the president cannot directly introduce legislative proposals for consideration in Congress. However, the president can take an indirect role in shaping legislation, especially if the president's political party has a majority in one or both houses of Congress. For example, the president or other officials of the executive branch may draft legislation and then ask senators or representatives to introduce these drafts into Congress. The president can further influence the legislative branch through constitutionally or statutorily mandated, periodic reports to Congress. These reports may be either written or oral, but today the greatest in importance are given as the oral State of the Union addresses, which often outline the president's legislative proposals for the coming year. Additionally, the president may attempt to have Congress alter proposed legislation by threatening to veto that legislation unless requested changes are made. In the 20th century, critics charged that too many legislative and budgetary powers that should have belonged to Congress had slid into the hands of presidents. As the head of the executive branch, presidents control a vast array of agencies that can issue regulations with little oversight from Congress. One critic charged that presidents could appoint a virtual army of czars, each wholly unaccountable to Congress yet tasked with spearheading major policy efforts for the White House. Presidents have been criticized for making signing statements when signing congressional legislation about how they understand a bill or plan to execute it. This practice has been criticized by the American Bar Association as unconstitutional. Conservative commentator George Will wrote of an increasingly swollen executive branch and the eclipse of Congress. According to Article 2, Section 3 of the Constitution, the President may convene either or both houses of Congress. If both houses cannot agree on a date of adjournment, the President may appoint a date for Congress to adjourn. For example, Franklin Delano Roosevelt convened a special session of Congress immediately after the December 7, 1941, Japanese sneak attack on Pearl Harbor, and asked for a declaration of war. Brought to you by WikiVidi Documentaries. Would you like to know more?